UK Tax Podcast, the Statutory Residence Test and Exceptional Circumstances. With John Kavanagh.
Welcome back to the UK Tax Podcast. My name is John Kavanagh and I am a chartered tax advisor with my own private practice. I mainly advise other professional advisors, but also private and business clients. I've been working in tax for 40 years and have been a chartered tax advisor for well over 30 years, so I hope this podcast will offer something useful. In today's episode, I want to cover a particularly significant decision from the Court of Appeal, which was handed down in February 2025. The case is anonymised and known as A Taxpayer v HMRC for reasons that will probably become obvious as we go on, and it focuses on how the Statutory Residence Test, or SRT, treats exceptional circumstances. Specifically, the case concerns when a taxpayer might be considered to be prevented from leaving the UK due to exceptional events beyond his or her control. The facts of the case illustrate how personal circumstances can sometimes clash with the strict day counting requirements of the SRT. The taxpayer in question moved to Ireland in April 2015 and was seeking to establish non-resident status for the 2015/16 tax year. Under the SRT, this required her to spend no more than 45 days in the UK during that year. However, she ended up spending 50 days in the UK. The additional days were directly linked to her twin sister's serious health crisis. The sister, who lived in the UK, was suffering from severe alcoholism and associated mental health issues, requiring urgent care. She also had two young children whose welfare was at risk, leaving the taxpayer with what she considered to be a clear moral duty to step in and help. The taxpayer argued that these additional days fell within the exceptional circumstances exemption in the SRT rules, which allows days to be disregarded if the taxpayer is prevented from leaving the UK due to exceptional circumstances beyond their control. At the First-tier Tribunal, the taxpayer was successful. The tribunal took a sympathetic view, holding that the combination of her sister's medical crisis and her responsibilities towards her young nieces or nephews created exceptional circumstances that prevented her from leaving the UK. However, HMRC appealed this decision, and in its own decision, the upper tribunal took a far narrower approach. The upper tribunal focused heavily on the word prevented, interpreting it to mean that a taxpayer must face either a legal prohibition, such as a court order preventing departure, or a physical impossibility, such as being too ill to travel themselves. In the upper tribunal's view, the taxpayer's situation, though distressing, did not legally or physically prevent her from leaving the UK. The fact that she felt a moral duty to remain did not, in the upper tribunal's analysis, meet the test, as in the final analysis, it was a choice to remain, not a legal obligation. The taxpayer appealed to the Court of Appeal, which took a much broader approach, ultimately reinstating the First-tier Tribunal's original decision. The Court of Appeal rejected the upper tribunal's narrow interpretation and held that the concept of being prevented from leaving should not be artificially restricted to physical or legal barriers. Instead, the court recognized that there could be compelling moral and family obligations which could, in reality, leave a taxpayer with no reasonable choice but to remain in the UK. The court took the view that the exceptional circumstances exemption should be applied in a way that reflects the realities of human life rather than being confined to rigid legal or physical constraints. It is important to emphasize that this is not necessarily the final word on the matter. Her Majesty's Revenue and Customs may well seek permission to appeal the case to the Supreme Court, so the position could yet change. For now, however, the Court of Appeal's judgment stands as an important clarification, showing that exceptional circumstances under the SRT can include serious moral and family obligations, not just legal or physical restrictions. I am not a betting man, but my expectation and hope is that the Supreme Court would affirm the Court of Appeal's decision if they do hear an appeal. As always, remember these podcasts are most certainly not a substitute for professional advice, which must always be tailored to your specific circumstances. Professional advice is absolutely essential for anyone whose UK resident status is borderline, particularly if they need to spend time in the UK for reasons that are arguably beyond their control. I'm John Kavanagh, and I'd like to thank you for listening to this episode of the UK Tax Podcast. More episodes are on the way, and I very much hope you will join me again for the next and future episodes.